Court is now in session with your host, Peter Briggs.
Welcome to the Lawyers to Lay People podcast, a conversation-based podcast featuring interviews with some of Georgia's top lawyers, where we, in an easy-to-understand, non-lawyerly way, answer the questions that are on the minds of you, the layperson. In this podcast, we talk to specialists in a particular field of law to hear directly from them as to what clients typically ask them and what they should be asking. I'm your host, Peter Briggs. A little about me. I'm a personal injury and bankruptcy attorney as well as a registered mediator, currently practicing in Atlanta, Georgia. I graduated from law school in 2006 from Georgia State University, and I've been practicing as a lawyer for almost 17 years. Today, we're joined by Ryan Schwartz. Ryan was born and raised in Baltimore, Maryland. After graduating from the University of Wisconsin-Madison with a Bachelor of Arts in Economics and Political Science, he then earned his MBA from the University of Baltimore. After several years in business, Ryan decided to pursue a lifelong dream to attend law school, where he graduated from John Marshall Law School in Atlanta. After law school, Ryan was a prosecutor for a few years before starting his own practice nearly 9 years ago, focused primarily on representing people charged with everything from traffic tickets to DUIs to misdemeanors to felonies. He has represented people in drug offenses, domestic violence, sex crimes, theft offenses, and has represented over 1,000 people, including everyone from regular people up to CEOs, entertainers, and celebrities. He has grown his practice to include personal injury, representing people hurt in automobile collisions, slip and fall, and premises liability. Welcome to the show, Ryan.
Thanks for having me, Peter. Good to be here.
Great. So I know you do personal injury as well as criminal law, but let's talk about criminal law. What is it you like best about criminal law? Why is it you were attracted to that area?
Well, what's great about criminal law, it kind of gives me an opportunity to think outside the box and to help people in their time of need when they have a challenge and help them get from A to B and get over that problem. And I love that. I love helping people through that challenge in their life.
Now, are there any circumstances where an accused can get by without hiring a lawyer, or if you're charged in the most minimal of offenses, is it something you can get by representing yourself?
Well, certainly anyone can attempt to do that. I always tell people all the time that if you have an interaction with law enforcement or you have a case in the court system, you should always have a lawyer. Certainly, it's your right to move forward without a lawyer, and certainly if you have a minor, like holding a cell phone or a minor speeding charge, you might be able to get by, but it's preferable to have a lawyer at every step of the way when you go to court.
So what should a potential client be looking for when deciding whether this particular lawyer they're interviewing is the best fit for their particular case?
I think it comes down to a personality fit. There's some people that want someone who's very intense or someone who they can get a hold of at all hours of the night. Sometimes people want someone who has won a lot of cases or has a lot of notoriety in the media. I think it comes down to, can you get along with that attorney? Can that attorney meet the demand of that client, and can they work together to get through this problem? I think that's what it comes down to.
And to that point, how important is a personal connection between the client and the lawyer towards getting a good result to the case?
Well, certainly it's important to have some kind of rapport. And a client, when they come to meet with a criminal defense lawyer, they should never hire a lawyer to get a certain result. They hire a lawyer to defend them in that charge, obviously hoping for the best possible result. But again, you don't hire someone to get a result for you, but certainly having a rapport and some kind of working relationship is, I think, essential to getting from A to B.
So once you have been retained by a client, do you have a list of rules or anything standard list of rules that they should follow once you've decided to represent them?
Well, certainly I live by that motto, especially with domestic violence cases and cases involving victims or other parties. Loose lips sink ships. So I always tell clients to keep things close to the vest and not talk about the case with too many people. Certainly with like DUIs, there's certain requirements that lawyers like clients to get done before they go to court. But I think the general rule is stay out of trouble and talk about the case with as few people as possible so we can work on our defense and our strategy and not involve too many outside parties involved in the case.
So to that point, I'd imagine there are circumstances where a family member comes in and is trying to help out the accused, who's another member of the family, and they pay your fee even though they're not the accused. So can you explain to the listeners what happens in those circumstances? Who is the client? What can be said to the party who's paying, who's not actually the one being accused?
Well, certainly the one who is on the contract, the one who I'm representing, that's the client. So despite, even if the mother or a father or someone outside party or other family member is paying the fee, I don't have an attorney-client privilege with that other party. It's with the client. So if the client says to me, I don't want my dad knowing anything about the case, and the dad just paid the fee, I will make that clear to the father. I'll also have the client sign something on my contract putting in writing that I'm not to talk about the case with their dad or other parties. Now, alternatively, if they want me to discuss the case with that family member, I'll have them write that, sign off on that, so there's no miscommunication as to who I should or should not be talking to about the case. But generally, I will communicate with that client, not the family member.
And can you just explain to the listeners the concept of attorney-client privilege and how that comes into play in these scenarios?
Well, attorney-client privilege comes into play when you form that relationship with that client, even if they don't necessarily hire you, but if they've come to you in a attorney-client capacity and they're talking about their case, that has been formed. When you sign that contract and you start moving forward, I make it very clear that what we talk about is between us. I'm not going to share what you tell me as the client with any other party, including a prosecutor, a investigator, other family members, unless I am authorized by that client, because it could be detrimental to the case, and you could be talking about important facts or strategy with a family member, and they could, talk about that with other people, and it could get back to the wrong party, and that could damage the case.
So let's talk about your fees. How are criminal law attorneys typically paid?
So criminal defense lawyers are typically paid up front. It's a fee earned, and what happens is if I charge you $5,000 and I can work out a payment plan or whatever kind of arrangement, I'm going to get paid that fee, and that is my fee for the case. And unlike a contingency lawyer or a family lawyer, or when you do personal injury, where you're getting paid on the back end of the case, or in a divorce case where you're getting paid a fee and it goes into a trust account and you can bill against that, criminal lawyers get paid and that's their fee. Now they have to do the work and they have to agree to represent that client, but that fee that is paid, that's a fee earned.
And how do you go about kind of figuring out what an appropriate fee could be for a case?
Well, certainly early on in my practice, I would talk to other lawyers, people I know that I trusted, and ask, well, how do you determine what's kind of a going rate? And then you talk to other people, and certainly you kind of get a feel when you're out there what that client can pay. Certainly, I'm not going to charge someone $100,000 for a DUI, but I'm not going to charge someone $1,000 for a homicide. It's kind of, there's certain pressure, there's certain lines that you're not going to go below, but certainly there's a wide variety of fee structures that you could create and work out with the client.
So are there some times where the fee is paid in full at the beginning of the case, and then other times where they continue to pay you as the case continues?
Absolutely. Sometimes there's a client will hire you, let's say, for example, to do a bond hearing, to get them out, and they have the intention of hiring you and later on, but they don't have the funds. So you can work out a payment plan. Sometimes there's people, they have the money, they have the means to pay up front, and they just want to get it over with, and that's fine, and they'll pay that up front.
So do you take appointed cases, and how do those differ if you do?
I do take appointed cases. There are several judges out there. I'm on their appointed list, and they don't differ in my representation of them. There's no money that is discussed between those appointed cases, because what happens at the end of the case, when I'm done, I can submit an invoice to the court for my work, and then I'll get paid a agreed upon rate that the court system has with those attorneys, with the appointed attorneys.
And How do clients typically find you? Is it word of mouth, internet? How exactly does that work?
Sure. There's several ways. Having done this for many, many years now, I have a good book of business, and I get a lot of referrals from many different sources, from companies, from different civic organizations, religious organizations, social media plays a huge part in that. People find me on social media and different listservs, and word of mouth. But certainly there's also an element of online marketing and Google and things like that. There's several different ways clients come in.
And do you sometimes wind up getting contacted by someone who has already had an attorney represent them, and that attorney-client relationship failed for whatever reason, and they come to you? Will you take that case if you're not their first attorney?
Absolutely. However, I'm very serious about not creating an ethical dilemma, and I'll tell people all the time, I'm happy to take your case, but you need to end that relationship with that previous attorney, and I need some kind of communication that relationship has ended. I certainly have had people that have, come to me and they've said, listen, I don't know if this is the right fit. I'm going with this other attorney. And that's fine. However, I always think that's a distaste, at least a distaste in my mouth when that attorney didn't even have the courtesy to reach out to me first or make sure that relationship with that client has ended before they've moved forward. So I make sure from ethical standpoint that I'm not stepping on anyone else's toes. That's just a personal thing that I do because I think it's the right thing to do.
And when you've been contacted as the second attorney, is usually the reason they've wound up deciding to switch attorneys just because of a personality fit, or is it sometimes something else?
Sometimes the client might believe that first attorney can't get them there to that finish line, or they've gotten a recommendation from a friend. Hey, you need to talk to Ryan Schwartz, and for whatever reason, they want to get a second opinion or talk to another attorney. It could be a dispute with money with that first attorney, or a conflict has developed, or sometimes the attorney has gone MIA, and they just won't communicate, and that level of communication, where it's at, that's not comfortable for the client. They want someone who they have more access to, and that's something that I provide in my practice. I give more personal attention than a lot of other attorneys will.
And I heard you mention second opinion. Can we just clarify for the listeners, when a client is represented by an attorney, really in any kind of case, doesn't have to be criminal law, is there any sort of restriction about them talking to another attorney to try to get a second opinion? Anything that they...
There's certainly not a restriction, but I think it's unethical for an attorney to start splurging and giving all kinds of advice and how they would represent the client, because you're divulging kind of your strategy, and they're not even your client. And I feel like that steps on the toes of that first attorney. And so I make a point of always telling the client, listen, if you're not happy or you have some concerns with your first attorney, I would sit down and speak with them and tell them your concerns and tell them, you need your questions answered, rather than trying to steal that client or sign them up. I never do that.
Now, what are some of the common complaints you hear from clients about just either criminal law attorneys or perhaps just the criminal law system in general?
Well, most clients, and rightly so, are upset with the process and the longevity that it takes to resolve a case. And unfortunately, that speaks to the disorganization of our criminal justice system and various prosecutors' offices in the Atlanta metro area. That is an unfortunate side effect of how the criminal justice system and the courts are set up. A bigger complaint, though, is that a lot of times clients can't get a hold of their attorney. It's an innate quality that we as people, we want to be able to get a hold of someone and talk to someone who's helping us. We don't want to be put off to a junior associate or a paralegal or a secretary. And I think I recognized that early on, and having a business background, I kind of recognized that the way you treat people in their time of need speaks volumes about who you are as a person. I'd want to be treated. I'd want to be treated a certain way, a certain modicum of respect if I were in their shoes. And I think a big complaint that clients have is they don't feel like they're being treated fairly by either the attorney and or the system or there's a variety of reasons, but those are two of the biggest ones.
So if a client needs to reach you, typically, how long does it, let's just say you're in the middle of a trial or deposition or something, how long, sort of, even if you've got that going on, is the longest it would take you to just get back to a client?
I've never taken more than a few hours to get back to a client. Typically, if they call me or they'll send me a text or an email, I need to speak to you, and I'm tied up, I will write them back and communicate to them, listen, I'm busy, I will get back to you. Is it okay if I call you this evening? And 100% of the time do I get back to that client. I never put them off. I never will call them back a week later. That's just not how I run my business and market myself.
And are they, just to go back a little bit to fees, if when they contact you, each time they contact you, are you essentially charging them for it, or if they paid for it up front, how does that work?
They've paid for it up front, so I open myself up to to my time and to communicate. Now, certainly, if clients are calling me every single day, I'll certainly, and there's no updates and there's nothing to discuss, and they just want to know what's going on, certainly I'll have that conversation with them that, this is not something that we can talk about every day. There's nothing to talk about yet because we don't have discovery or there's nothing new or relevant information. But certainly when clients want to meet and discuss evidence and talk about strategy, I don't bill them for each call and each meeting. That is built into the fee that I have worked out with them at the beginning of the case.
Now, how important is it, the jurisdiction you're in, the venue you're in, to the outcome of a case?
It's paramount. It depends on the case. So if someone calls me up and they're in, without getting specific about certain jurisdictions in Georgia, you can have a certain jurisdiction that's more conservative or maybe further outside Atlanta, and they might have a case that I know that's a challenging jurisdiction, and I might have a higher fee for that case, whereas that same case in downtown Atlanta, I might have a different fee structure because I know it can be worked out a certain way, or I'm going to have a more successful rate at trying that case if I go that route. So I think it's essential and paramount to the case.
Now, I'm sure you explained that to the client, but how easy is it for certain clients to understand that if your case were in this county versus that county, it may be a totally different process, either in longevity or, most importantly, the result of the case?
That's a major challenge and a major talking point when you're meeting with the client and explaining to them, because a lot of times clients will say, well, listen, I have a friend who had the same charge, but it's in a different county and there was different circumstances, and I'll have to explain to them, well, that's how it might work in that county, but in this county, let me tell you kind of how it works. And so it can be a challenge. Sometimes clients don't understand, well, I don't understand why this is a big deal. This wouldn't have been a big deal in New York or California. And you have to kind of bring them back to reality and explain, well, we're not in those other jurisdictions. We're here, and here's what goes on down there. And I'll sometimes discuss certain prosecutors or who the DA is, and there's certainly challenges with maybe who that person is, or there's a bias or something like that, and certainly we have to work around that.
So Georgia has a ton of counties, I think maybe the most in the country, maybe something like 160. I'm not sure. How many of these counties have you actually practiced in by this point?
I have been in every county, obviously in Atlanta and the surrounding counties, and then typically the surrounding counties outside of that. I've done several of the counties in the Savannah area, northern Georgia, and southern Georgia, but certainly, and in middle Georgia. I have not been to every county. I probably haven't even been to, I would venture to say, half the counties. I've not kept track of that, but I've been to many counties, and I've represented well over 1,000 people in a variety of criminal matters, as you stated in the bio, ranging from traffic tickets all the way up to serious felonies.
So basically, though, within the metro Atlanta area and immediately surrounding, you've seen pretty much how all those counties operate.
Absolutely, yes.
Okay. So outside of just, of course, taking your advice, how should a client know or be with things they should be considering when they're being confronted with a plea deal as to whether they should take it? How do those conversations typically work?
Well, there's so many factors that go into the makeup of a case. It's kind of like a chess game. Like, I move, you can't talk about the end of the game till we see what kind of player I am, right? Or what your opponent is. So you have to factor in, what is their criminal history? Is if there's a victim involved, if it's someone they know, have they ever had a previous case involving this victim? Have they had previous charges before? Are they on probation? Are they, do they have other charges in other counties? There's so many factors. Is this a case that where the facts are weak for the state that we think we can prevail in trial? Is this person, do they have responsibilities in their life? Mortgage, job, children? Are there certain things that if they opted to go to trial, and if they lost a trial, is this something that's going to affect those factors? There's so many little factors and situational things that need to be reviewed before someone just says, I'm going to take a plea deal.
And when you have that conversation with the client, how does that typically go? Are there certain things that they, get focused on that maybe you're not focused on? Well,
certainly there's a variety of emotions ranging from absolutely, let's take that, to, very upset. They think the case should be dismissed, or I want to go to trial. So there's a wide variety of emotions and feelings that go forward depending on the nature of the charge or who the client is or what's going on in their life.
All right, so we've talked a little bit about sort of questions that the layperson would have about this process. Let's transition a little bit to speaking now to a lawyer, maybe a younger lawyer who's just fresh out of law school and is interested in criminal law, or perhaps someone just in some other field that's interested in transitioning to criminal law. What would you say is the best way for a young attorney to learn about how to practice criminal law?
Well, I think it's really important to understand both sides. And I always tell people, kind of like what I did when I was in law school, I interned at several prosecutors' offices so I could understand how those offices worked and how to understand cases from their perspective. So the advice that I always give people is to, if they're in law school or close to finishing law school, intern at a prosecutor's office, but also intern with a criminal defense lawyer, someone who's in trial a lot, someone who they can sit with and understand the analysis of a case and how cases are analyzed and reviewed, because there's no substitute for experience and kind of getting that on the ground training.
Now, for a younger lawyer who's trying to handle both the business aspect of growing their own practice as well as the competency aspect of becoming a great trial lawyer, how do you advise them if they're opening up their own practice? How do you advise them to split their time between trying to get business and then trying to do a great job with the business they bring in?
So that's not a straightforward answer. It's something that it's taken me years and I'm still learning how to do that. You have to make mistakes. And the only way you're going to be successful and learn where you should be putting your valuable time is to make the mistake. There's some lawyers that put all their time into being in court and wanting to help people, but then you kind of neglect the business side of it and you're not growing your business. And then there's lawyers who they do a lot of the marketing and all of that, but then they don't have any cases to kind of showcase or what they're doing. And I think it goes hand in hand. You always have to put yourself out there. And certainly we live in the world with social media and all kinds of different online marketing techniques and things that people can do. But certainly I think you have to figure out what you're comfortable with. There's some people that are really comfortable in front of the camera or on radio or in print, and you have to lean into your strengths a little bit and figure out what that is. And you're not going to know that until you make mistakes and you kind of are in the field doing that.
So let's talk a little bit more about the business side. How do you, I'd imagine there are circumstances where you're trying to get more business and maybe you're quoting a fee below what you would prefer to quote, or you've got a client who simply is financially constrained to pay your fee. So how do you keep yourself from being in a situation where you wind up basically working for free or close to free?
Sure. Now, in the beginning when I was starting my practice, I would take anything for any fee because I wanted business. I wanted to get out there. I wanted to get my name out there. As I've been transitioning more into personal injury, my tolerance level for negotiating with my fee has drastically gone down. I think it's really important as a lawyer to not price yourself out. So if we know, let's say lawyers for a DUI are quoting $4,500, $5,500. It's really important not to come out and say, listen, I'll tell you what, I'll do it for $1,000 because you just want the business. Because what if that client turns into a problem client? You never want to devalue the skill set you've developed and the insight that you have and the experience you have, because there's value to that. And it's when clients see that you have shortchanged yourself and you've reduced your fee, you're now open for a negotiation, and that kind of puts you in a weaker spot in that attorney-client relationship. It makes it look like you'll just take anything for anyone and do anything no matter what the price. So I'm very clear with people, here's my fee, I'm not going to go below that, but here's what we can do. We can work something out. If you want to hire me for that fee, we can kind of work out an arrangement, a payment plan. But I tend to, especially now that I've really grown my practice, to include I do a lot of personal injury now. I'm not going to sell myself short and reduce my fee just to grab that client and bring them in.
Now, payment plans, are those the kind of things that you could potentially run into trouble with as far as ability to pay? Absolutely.
Sometimes you'll get clients who you'll work out the way I do a lot of payment plans now is I'll take half down. So if I quote a fee, let's say $10,000 is my fee, and I'll say I need $5,000 down. They'll say, well, can I get you $1,000? And I said $5,000 down. And what happens is if they might call another lawyer till they find what they want. That's fine. But if you get that client that gives you that half down, and then we've worked out this payment plan on the back end 5, a lot of times what will happen is a client will lose their job, or something will come up in their life and you'll lose their phone number, or they'll get a new email and you can't get a hold of them. And now months have gone by, they've missed several payments, and you get into that period where, well, the case is not yet on a calendar in, let's say, Gwinnett County, who takes a long time to get a felony on a calendar. I'm okay that they haven't paid me yet because the case hasn't come on the calendar. However, I'm also at the same time bothered by the fact that they've missed several payments. So I'll have that conversation, and usually, in my experience, you'll work out a new arrangement, but you have to set that expectation early on. You are going to meet these guidelines. These are the dates, and these are the payment amounts you've met. If you don't meet that, then that gives me a right to withdraw from the case or not represent you if you're not going to honor the contract that you signed.
And by making that decent down payment, they've got skin in the game.
They've got skin in the game. That's why I do it that way. Because it shows, if you start off small and you quote someone $10,000 and you say, well, I'll take $1,000 down. I want $1,000 a month. And then second month comes and they say, well, listen, I have $800. I can give you the full $1,000, but it's going to be another month. So now they've taken advantage of you. They haven't met that agreement for that second month. And if you play into that and you say, okay, I'll take the $800. And then month 3 comes and they say, listen, it was a slow month at work. I only have $300. There's no skin in the game for them because they're treating you like one of their friends or someone that they can keep working deals with. And that you have to make it very clear that your time, your experience, your value is not up for negotiation.
Now, you mentioned just a little bit ago about time to trial, and you were referencing a county that takes a while. Can you just explain to a young lawyer, I'd imagine you sometimes have clients who maybe they've even paid your full fee. They really want to get this thing over. They're really antsy to get it concluded. And on the other hand, the court system isn't running so fast. So how does that come into play sometimes where you've got the client who really wants to get it done and you just can't seem to conclude it through circumstances outside your control?
Well, I tell clients all the time that in a criminal case, time is your friend. You want as much time to pass because witnesses disappear, people change their mind, evidence gets lost, investigators get off the case and they're gone, or law enforcement personnel, there's a high turnover, they will change jobs and they'll leave the jurisdiction. I give numerous examples of people I've represented. When I'm talking to a client, I tell them about, let's use a DUI for an example. If you have a case in Fulton County, I can't tell you how many cases I've had where an Atlanta police officer I'll have a case in a municipal court in Atlanta, in Fulton County, and we couldn't get it worked out the way we wanted it. And I'll say, let's send it over to Fulton County. There's a 24-month turnaround. There's a very high probability that officer won't even be working at that law enforcement agency. He'll be living in California working for the railroads. That is an actual thing that has happened to me. In many cases, the officer will disappear. When it gets to Fulton, they don't have their star witness in pocket. They can't proceed with the case the way they want. So I give examples all the time to the client to temper their expectations so they understand you might want it over right away. I want to make that happen for you, but we have to kind of play into the error that the prosecutor has created by creating this lag time. Let's play into that because it typically will play to the advantage of the defendant.
And even though it does, do they just sometimes just find it very difficult to have that kind of lingering over their head for that many months?
Certainly, sometimes it's years, and certainly that is a concern that certain clients have. And things come up where they'll say, "Well, what can we do?" And certainly, I'll if there's an exceedingly long period of time and nothing's happened, typically I'll reach out to the prosecutor, and a very high percentage real high percentage of those cases the prosecutor will come back to me and say, listen, we haven't reviewed the case yet, or it's not on the calendar. And I'll explain to the client, listen, they're not ready to play ball. They're not here to play ball yet. And I think we need to play into that, because if they're not ready and we know that our witness is gone, or their witness is gone, it's something that they need to understand that they're just going to have to be patient. Certainly there are lawyers that think differently than me on that, where they'll file speedy trial demands against prosecutors. I think that is a crucial error in judgment on a defense attorney's part, because that does nothing but piss the prosecutor off. And they have to put all these other cases that they're working on the back burner to handle your case. And you will be, as the defense lawyer, people who do that regularly, file speedy trials to get things moved, they are held with a certain level of contempt by prosecutors. And they get a reputation for doing that. And I think that's a bad reputation to have in this town.
Now, how do you go about getting a case resolved short of a jury trial, typically?
Well, certainly there's an offer that's made, and sometimes you'll go back and forth with the prosecutor. The prosecutor, you have to make the prosecutor aware of who your client is. To the prosecutor, that's just a file. They don't know your client. They don't know their life the way you do as their defense attorney. And sometimes you need to school the prosecutor on either the law or what's really going on behind the scenes. And I can't tell you how many times that has happened where if you can just get a good ear and a sympathetic prosecutor understand your position and what's going on, sometimes they come around and they'll work out something that was never on the cards to begin with, or that it was never discussed to begin with, and you'll get something worked out, and it can play to the advantage of your client. Certainly, a lot of times clients will watch TV or movies, and they'll think that's the way it should go, and you have to kind of explain that you're not charged with a case, and then a week later you're in trial, like on TV and movies, and many clients are perplexed by that concept because they think what is out there for entertainment purposes is what's going to happen in their actual real-life case.
Yeah, so you mentioned, I think you said, talking about teaching the prosecutor to your point of view. How much of that is done by you digging in and doing an investigation and perhaps learning things that you can now show the prosecutor that the prosecutor just wasn't even aware of when they brought forth the charges?
Well, certainly there's an element there of doing your own investigation. Sometimes you play it into cases where the prosecutor thinks they did a great investigation and they didn't, and you'll go do something and learn something, and despite giving them new information that hurts their case, they'll still want to proceed. I've had several cases without, again, giving prosecutors names or jurisdictions way where I knew for a fact the prosecutor didn't know what they were talking about. I played into that. I've gotten cases dismissed because I knew they didn't know what they were talking about, and I called, you kind of call their bluff a little bit. But certainly for the defense lawyer, your job is to investigate, understand the facts, understand the evidence and what is being presented to you, where the defense is, if there's a defense. Because just because the officer said X, Y, Z and they smelled marijuana, well, I wasn't there. The prosecutor wasn't there. What if the cop is lying? Maybe we can go get the officer's disciplinary records. Maybe we can talk to other lawyers who might know that officer and where their weaknesses are, and maybe you'll get some little tidbits here and there and how you can kind of play into that a little bit. So certainly there's several components. A big one being your own investigation, understanding your case, your client's case, and their life, so you can kind of go into the case and be able to help your client.
So let's transition back a little bit to the business side. Looking back at the start of your career in private practice, which I think was about 10 years ago, what is the one thing you would, now tell yourself that you wish you had known at that point?
I wish there are a lot of, there's so many things, and I said just one.
But you can expand.
I think if I had to really do it over again, I would have done more personal injury internships with injury lawyers when I was in law school. And when I came out, maybe I wouldn't have just done criminal. But I think that's a great question, Peter. I think I would have made sure I was aligned with some of the less unscrupulous lawyers in this town than that I went to for advice. And I think there's a lot of people that will steer you in the wrong direction, or you think that they're the right people you need to get advice from, and you later learn those are the wrong people to know and to ask advice from. And I think everyone makes those kind of mistakes, and that's how you kind of learn and grow a successful practice and become a successful lawyer, is learning from those mistakes.
Right. So is that pretty much just a trial and error thing, or is there some other way you can?
I think with any success in life, there's trial and error. I don't think anyone who comes out, and I think to the previous question, I think not getting caught up in appearances and the flash. There's a lot of lawyers out there, obviously in this town, who the average person might think they're really successful and they know what they're doing because they have the nice car, the nice watch, or they have a nice, commercial. And 99% of that is smoke and mirrors. And I think learning that treating people right and doing right by people and making sure the client is at the center of your thought, I think that's the biggest lesson I can give someone, and that I wish someone had just imprinted on me when I first got out, because that's what I've learned and that's what I carry with me. But I don't think it's something that I can tell you. I think you need to have trial and error and make mistakes to really understand your brand and why you're in this business. Because if you're in the business to be a lawyer because you want all the flash and you want to have a fancy buckhead billboard and you want to have a crazy commercial on TV, you're in the wrong business. I think you need to be in this business, whether you're doing personal injury or criminal defense, you're in it to really help people and to really make a difference in their lives. And that's the essence of what we do, of what I do.
Well, I think that was a great way to conclude this podcast. I want to thank Ryan Schwartz of Schwartz Trial Law for joining us on this podcast, and to thank you for listening. You can find Ryan at schwartztriallaw.com. That's SCHWARTZ triallaw.com. You can visit me online at brickslaw.com. That's BRICKSLAW.com. You can also rate or review us wherever you get your podcasts, Apple Podcasts, Stitcher, Spotify, Google Play, or wherever. All of our contact information can be found in the link below. And for more details, you can email me personally at peter@brickslaw.com.